The man who brutally killed an 11-year-old girl out in Texas just pled guilty and was sentenced. As the family of Audrey Cunningham delivers emotional victim impact statements, we try to make sense of this conclusion. Was it justice? Why no death penalty? And when looking at his past, could this maybe have been prevented? Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. We're trying to make sense if justice was served after a plea deal for a child killer. We're talking about Don Steven McDougal. The 43-year-old pled guilty to one of the 2 counts of capital murder he was facing in connection with the savage killing of 11-year-old Audrey Cunningham. This is out of Livingston, Texas. It's about 70 miles from Houston. This was the girl who was reported missing back in February of last year after she never made it to school. And 5 days later, her body was found in a river tied to a rock. The medical examiner concluded that the 5th grader died from homicidal violence, including blunt head trauma. And McDougal, he was a family friend, lived on a trailer on the family's property, according to CNN. This is a guy with a criminal history, and we're going to talk about that. He had the responsibility of taking Audrey to her bus stop the morning that she vanished. What was the evidence against him, aside from the fact that he was supposed to be watching her? Well, he lied about where he was and what he was doing. There was also video footage. There was cell data. The rope that was used in connection with tying her down was apparently consistent with rope that was found in McDougal's car, according to court documents. And now he has pled guilty. And as part of that plea agreement, he gets life in prison without the possibility of parole. According to Click 2 Houston, that means his other capital murder count was dropped, indicating the prosecution could have potentially been able to present more evidence for that charge, but not clear what that evidence was, and it wasn't disclosed to the defense. Additionally, Click 2 Houston has also reported that the prosecutors dropped McDougal's other 4 pending criminal cases per this deal, and it's not because there wasn't enough evidence to convict him in those cases, but they say as a matter of practicality, it didn't make sense because he's facing life in prison now. Those other charges wouldn't have really affected that. Polk County Criminal District Attorney Shelley Bush Sitton released a statement saying the Polk County District Attorney's Office is announcing today that Don Steven McDougal has accepted responsibility for his actions in the kidnapping and murder of Audrey Cunningham. Don Steven McDougal will spend the rest of his life behind bars without the opportunity to appeal or seek parole. This agreement reflects the gravity of the offenses committed and ensures the safety of our community and our children. And as for why there was no death penalty here, well, Sitton stated, after intense and diligent review of the law and medical records, the determination was made that Don Steven McDougal was not eligible for a death penalty sentence under the existing law. This resolution ensures that McDougal is being punished to the fullest extent available under the law and spares the family the emotional toll of a prolonged trial and appeal process. Now, before we get into what was said at his sentencing hearing, and there were some things that were said, I want to bring on Texas attorney Jeffrey B. Simon to talk more about this. Jeffrey, thanks so much for coming here on Sidebar. We appreciate it.
Thanks for having me.
Overall thoughts on this crime before we even get to the law of it? I mean, I'm curious, was this a case that was talked about a lot in your state? It's not every day you hear about an 11-year-old who's killed and found in a river tied to a rock like this. Your overall thoughts on the actual crime?
That, in addition to its heartbreaking nature and some questions about why the family allowed this person to be so close to their daughter, the case involves 2 very provocative legal issues, which can't be separated from the nature of the crime itself, because one of them helped the defendant commit this heinous crime, and the other helped him avoid the death penalty as punishment for it.
What are those provocative issues?
Well, Mr. McDougal, the defendant, had, as you point out correctly, previously pled guilty to having committed a sex crime against a child, specifically enticement of a child. But because he pled to a misdemeanor rather than a felony, he wasn't required to register as a sex offender in Texas. And that legal loophole proved to be very consequential in this case, at least according to Audrey's family, because they say they checked the registered sex offender list and he wasn't on it. And they say that had they seen his name, they would have never allowed him to be so close to them and, more importantly, to Audrey.
I'm going to get into his criminal history in a second, but look, the stories that we cover on Sidebar show that the world can be a pretty scary place. It's true. And for those of you thinking, how do I even go about protecting myself from all that's out there? Well, I'll tell you what, if you think about protecting your home, I mean, what property is more important than to protect than that? I didn't even know this, but apparently home title fraud is rampant right now. Yeah, so I met with the people over at Home Title Lock, and they're our amazing partner and sponsor, and they freaked me out. This is an example of a fraudulent quitclaim deed. So it got filled out with my information, a forged signature, a fake notary seal. Not only can my property just get transferred behind my back, but the scammers, they go after the equity. They take out loans using your home as collateral. They do all this, they disappear, and then they leave you with a legal and financial nightmare. But that is where Home Title Lock comes in to give you peace of mind, especially with their triple lock protection. Gets you 24/7 monitoring, alerts of any changes, and restoration services at no out-of-pocket cost to you. So to protect your home, you go to HometitleLock.com/sidebar. Make sure to use our promo code sidebar because you get a 30-day free trial of their triple lock protection and a free title history report to make sure you aren't already a victim. Okay, let's get back into this. My understanding is the family wants a law passed called Audrey's Law that would have made it a requirement for him to be on the sex offender registry. Do you know what the status of that is and what that would entail? What would that look like?
Well, I don't yet know what the status is insofar as I can tell you that the Texas legislative session just started. It started just a few days ago. So no doubt that law, if introduced and when introduced, will go through the subcommittee process and then perhaps on to the floor, both in our Senate and our House for vote, where if it then passes, would have to be signed into law or vetoed by Governor Abbott. Now, having said that, the idea that a sex offender, especially one who has preyed upon a child, should avoid or be allowed to avoid to register as a sex offender simply because they pled to a misdemeanor, I don't think makes sense to anyone, whether they have legal training or otherwise.
So the counter argument to that would be, well, he wasn't convicted of the higher sex crime. Why should he have to register? A mere arrest is a mere arrest. Now, looking at this case, I would say, yeah, he should have been on the sex offender registry. It would have given them notice. But I guess the counter argument is, how can you put somebody on the registry if they are arrested to something, but they ultimately plead guilty to a lesser charge? He wasn't convicted of the charge that would have put him on the registry.
Well, but he did plead. Now, I agree that if that to which he pled had no connection to a sex offense, then I would agree with that. But to the extent that he pled to enticement of a child or something related to it, I would argue that a sex offense is a sex offense.
Yeah.
And whether it is punishable as a felony or only as a misdemeanor doesn't change its very nature. And those who, plead down to something that is of a sexual offensive nature should register. They should be required to.
And I want to talk a little bit more about his criminal history in a minute. But going back to the facts of this case, do you have any doubt that he would have been convicted based on the evidence that we know so far in this case? I mean, let me rephrase. Obviously, a trial is always a risk. But based on the evidence that was presented, it seemed like a straightforward prosecution against him.
I agree. As reported, the evidence seemed overwhelming against him. And clearly, the decision to reach a plea deal had more than anything to do with what the district attorney felt were the constrictions on how to sentence him, specifically what she perceived to be the legal impediment to having him sentenced to the death penalty.
Is this justice, though? Is this justice in the sense that, yes, he's going to be spending the rest of his life in prison, no opportunity for appeal, no opportunity for parole, but one of his other charges was dropped? The other 4 cases were dropped. We could talk about the death penalty. The idea here is there was something in his background that made the death penalty impossible, whether it was the impediments of the law and the medical records. Because according to 6ABC, the DA's office had indicated that under Texas law, if there is a documented intellectual or developmental disability, that would limit a prosecutor's ability to seek the death penalty. So in other words, what I'm asking is this justice? Is this, I hate to say best because we're dealing with the death of an 11-year-old, nothing will bring her back, but is this the best resolution for this case, legally speaking?
Yes, if the district attorney is correct in her assessment that Mr. McDougal is so severely mentally impaired that he falls within the ambit of people that, according to the Supreme Court decision of Atkins versus Virginia in 2002, cannot be sentenced to death because their mental defect is so extreme that sentencing them to death for crimes they commit would be cruel and unusual punishment in violation of the Eighth Amendment. If he, according to his medical records, really fits within that spectrum, then yes, it's the best possible outcome or sentencing relative to that, because at least he will be in jail for the rest of his life where he cannot hurt anyone outside of the prison, and the death penalty is otherwise not an option.
And of course, you spare a family a very public and heart-wrenching trial of having to hear what happened to this 11-year-old girl. I get that. The one question I would have is there's obviously always disagreements between the prosecution and the defense over the death penalty. That's why we have a penalty phase, right? Prosecution puts on their evidence about why they believe the death penalty is appropriate. The defense presents their mitigating factors. Why not at least just present it to a jury? Or is it, look, the prosecutor's duty, if they believe there's significant evidence of intellectual or development disabilities, then by law, they can't put on a case?
If a criminal defendant is so severely mentally impaired that they fit within the category of defendants who cannot be sentenced to death constitutionally, then there's always the risk that a jury might not hold them fully responsible for the crime itself, that somehow they did not understand the nature of their crime or the difference between right and wrong or what they were really doing in terms of how they committed this murder. And if that was a real risk, then simply separating him from society forever does seem to be as close to justice as was obtainable.
That's a really, really good point. Yeah, again, risk of trial. I want to talk about the victim impact statements in this case that were delivered during McDougal's sentencing. And my understanding, right, I would be correct to say that as a point of law, their statements didn't affect the sentence, right? I mean, it wasn't going to change life in prison without the possibility of parole. But this is an opportunity for them to speak on behalf of Audrey and talk about what her loss and what this crime had on them. I would be fair to say that this wasn't going to affect the judge's decision, right?
That's true. But sometimes it does. And victim and family impact statements are a useful part of the criminal sentencing process for each of several reasons. One, they give crime victims and their loved ones an opportunity to express their grief as well as their rage at the perpetrator in a manner that's safe and legal for them to do so. They do, in some cases, help educate the judge who's about to impose sentence on the defendant as to how much harm he or she has caused by their actions. They provide a voice for the deceased victim from those who knew them best, loved them the most. And they can reveal, although in this particular case that wasn't important because the judge, it sounds like because of the plea deal, the judge knew exactly what the sentence would be. They can reveal how much the defendant does or doesn't bear remorse for the terrible harm they've done. In this case, Mr. McDougal reportedly didn't even look those who made their impact statements at all while they made them, nor show any emotional response. Now, that doesn't always mean that the defendant is just calloused and evil, although it certainly can. In some cases, it might be that there is some sort of disconnect to what's happening because of the nature of the mental defect. And in this case, we don't know. And as you point out correctly, it wouldn't have been consequential in how he was sentenced.
But let's talk about what he had to hear, because these were highly emotional statements. And as reported by Click 2 Houston, I'm going to go through some of them. So Audrey's father, Josh Cunningham, called his daughter the smartest, sweetest little girl, said to McDougal, "She gave my family purpose and you stole that from me. I hope you have a very short life sentence." Audrey's aunt said, "Because of you, we were forced to search desperately. Because of you, we had to bury our precious little girl. Because of you, we saw our community come together. There's no punishment severe enough for the things that you have done." Audrey's grandmother, Tabitha Munch, called Audrey a little angel and said to McDougal, "You took away the life of our little angel. Your punishment in this life will never fit the crime. Nothing will ever bring her back, and that's your fault." And she added, "May you rot in hell." Audrey's grandfather, Philip, called McDougal a monster pretending to be her friend and added, "May you burn in the eternity and the flames of hell." Now, Jeffrey, I have heard a lot of victim impact statements in my career here. You know, this is some of the most difficult moments in our legal system in a trial. Your thoughts on what this family had to say?
Well, obviously they spoke incredibly powerfully and painfully. And, it's a stark reminder that when a heinous crime like this is committed, it doesn't just end one life. it changes many for the remainder of theirs. I was struck by the comment, "I hope you have a very short life sentence," from Josh Cunningham, because one of the unspoken things in a room like that in those moments, people think about it. He was vaguely referring to it as vigilante justice in prison. Mr. McDougal is not going to county jail. He's going to a penitentiary for the rest of his life. And county jail is a tough place, but a penitentiary is a whole other matter, and can be especially so for inmates who commit crimes against children, which is what he did. And in no way, shape, or form am I suggesting that vigilante justice in prison is a good thing, but it does happen. And I do think that it was interesting that, at least as I interpreted it, Mr. Cunningham was at some level alluding to that possibility.
And I will tell you, this guy is no stranger to a life behind bars, because now let's go into his criminal history. So it was reported by CNN that we talked about before. He was convicted of enticing a child in 2007, pleaded no contest, sentenced to 2 years behind bars. In fact, according to People magazine, that victim was 10 years old when she was assaulted by McDougal, namely him trying to take down her pants. She had to fight him off. Then a few years later, he's convicted for aggravated assault with a deadly weapon, including using a knife, 4 years in prison. And apparently, when he was named as a suspect in Audrey's murder, he was already in custody on an aggravated assault with a deadly weapon charge, as per court documents that were obtained by KHOU 11. He apparently stabbed a man in the back. Now, it was reported by Click 2 Houston that Audrey's grandparents knew about his past, but they wanted to give him a second chance. But they weren't aware of the sex crime charge because, as we mentioned, he wasn't on the sex offender registry, and they say that he should have been. And as I mentioned, they want a law passed that would change that. According to Fox 26 Houston, her grandfather, Philip, said, "Our granddaughter was the second victim of his because of a loophole in the law that allowed him not to register as a sex offender. That was the only reason he was allowed to stay at our house. We were asked and we agreed to help him, and we've suffered the consequences." So it's really chilling to think about that, Jeffrey, when we talked about the idea of what would have happened if he was on the registry. But just think about his past. And the main question I have in a lot of these cases is somebody who continually breaks the law, how are they out? How is it possible they're out to commit more crimes?
I don't have a perfect answer to that, insofar as I don't know what the circumstances were involving the release from prison from one crime that he committed to the next. But I think that one of the questions that's implied is, why did the family allow someone with this known violent criminal past to be so close to them, both in proximity and in terms of entrustment with their child? He was supposed to take the child to school. And I am not implying in any way that any member of the family is responsible for Audrey's death. That's not fair, and it's not true. But a lot of that criminal history was known to the family, apart from the enticement of a child. And they decided that allowing him to not just live on the property, but be an integral part of their life and Audrey's life is not necessarily a choice that everybody who has learned about this case would have made for themselves. And people can decide for themselves whether these people were too trusting or simply were cruelly punished for being kind in ways that we should be kind. I don't know, but I do know that if a person has committed violent crime, there's every reason to believe they might do it again. And why he was able to be that close to them and to Audrey is as provocative as the question, why was he out of prison having been so violent in the past?
Yeah, and I don't have easy answers for that, for these difficult questions. But look, at the end of the day, this is some measure of closure for this family. Him being locked away, just a really tragic situation. And I appreciate you coming on, Jeffrey, to talk more about this. Jeffrey B. Simon, thanks so much. Appreciate it.
Thank you, too. My great pleasure.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.